I'm wondering if we're live right now. I gotta figure out where this chat's at. Chat. I'm using OBS on this one, y'all. Can I put this in here? There we go. Okay, so if I bring this up, bring this over. Alright, I'm using OBS right now. I don't know. Is everything working okay? Everything's good. Alright, good. That's good news then. It's pleasant. Glad that that's working properly. Let's see. I'm not showing no lag or nothing, am I? I'm coming through pretty clear. Again, I'm using OBS, so y'all bear with me. I don't need that. Okay, good. Good. Welcome back. This is going to be in relation to Luis's situation. If y'all don't know about what's going on with Luis, this is third time, third or fourth time going to court in relation to the violations that occurred to him. He had several constitutional violations that occurred to him, and oh, is everything okay? All right, good. So what I want to do is get the link, and we're gonna get into it. I know everybody's just coming in. Sorry, I'm a little all over the place, but let me get the link for Luis's situation, and we'll get to it. Get all this set up. I should have done this beforehand, but you know how it be sometimes, y'all. All right, let me see. Okay, it's opening up. Give me just 1 second. Everything's opening up. Power to the people. What's up, Joe? Welcome back, Lynn. What's up, Joe? Pig's daughter. Hey, preparing WebEx, it says. Is it opening the app or? Okay, it's opening. We're getting ready. Hold on. Hold on. Give me a moment. Okay. All right. Sign in. Oh, wait. I gotta go back. Join as guest. So we should be showing up right on time here, guys. All right. Perfect. Let's see what we got going on here. Join meeting. Let's see what we got. All right, we're in this thing. I don't know what that mute was for, but it looks like we're in this thing. All right. Now, if anybody else wants the link to come in here and show support to Luis, if you want, Cisco. Oh, I think this link's going to be too long even for the chat. Looks like it is. Paste. Oh, it fits. All right, so if you want to get into this, you can. There's the direct link. You can join from the browser or not. Totally up to you on that regard. Looks like we're set for a 1:30 appointment, but we don't currently have any movement or sound coming from the courthouse. I didn't know they had a chat, but we're going to get in the chat and we're going to say, we the people are here to support the dismissal of all charges in relation to Luis and his family. The Constitutional violations here are egregious and irreparable harm has already been done. All right. Nice. We the people are in here. Beautiful, beautiful, beautiful to see. Luis, I don't know if you're watching yet, but brother, we're in here supporting you, my guy. Love you to death, man. I miss you too. Just to talk about Luis for a second. So Luis is an amazing person. He went out, he drove, or excuse me, he traveled. Okay, homeboy just got done going out. I think he went all the way out to Virginia, if I'm not mistaken. You know what? Where's my damn ladder? I gotta spark up a joint. Hold on. Okay, so Luis, what's going on, Thomas? Yep, live again. Yeah, we got to get Luis today. We got to get Luis today. I'm not hearing anything from these people yet, so we're waiting to get some audio. But, um, oh dang it, what was I just talking about? Oh shit! Damn, I lost my train of thought. What was I just talking about, y'all? My memory's so bad. I smoked too much weed. I swear I'm bad with this. What was we just talking about? I don't know. Anyways, y'all ain't gonna remind me either. Lynn, if you called me, smoking in court is not allowed. It's not allowed. Oh man. So we're gonna wait and see what they gotta say. I don't know. It's kind of wild. But I forgot exactly what I was talking about. I was just talking about. Oh, my audio is low. Dude, this was the problem that I was trying to fix. I couldn't figure out why my volume is so low. Let me look real quick and see. Because there is no main volume thing that I can find in relation to just overall volume in and of itself. I've got the volume up, y'all. I've got my. I don't think this mic, this one right here. I'm gonna try it though. We're gonna see if it goes up anymore. But I don't. I swear I got the audio so loud. I don't know what else to do. I got it so loud. I swear I do. I've got it at 200%, and it still don't go up. I don't know why it don't go up, but it don't go up. I got it 200%. I can look into my settings though real quick. Hold on, let me see. Because I'm not lagging. I've adjusted my settings on OBS. So I just need to start using this because this don't lag on me no more. But the audio. Yep. Yep. Peak meter. True peak. Monitoring device. Default. Nothing in relation to overall volume. So see, I don't know how to. Now, see, it's still low. I don't know what to do in relation to the volume. I'm sorry. I don't know. I just don't know, guys. Settings, studio mode. I don't know what a studio mode is. I don't want to mess with that because I feel like I'll mess up something. Stream audio. It says I'm in stereo at 48 hertz. I just need a new mic. I probably need a mic and like some kind of amp to figure all of it out. But I literally got this bad boy turned up to the max. It's on the max, y'all. Okay. Mic is too loud, he says now. Well, see, now y'all gonna have me. Power inherent in the people. Check one, two, check, check, to check, check, check. Check one, two, check one, two, check, check, to check, check. Check one, two. Man, my volume's fine. What y'all tripping on, man? Check one, two, check, check, to check, check, check. I'm done with y'all. Y'all gonna make me not trust y'all no more. Okay. So I don't know what they got going on. I don't see Luis. It looks like they're just all in there chit chatting, having them a grandiose time. Oh man. Yeah, there's no volume going on in the courtroom. That's why you can't hear anything in the courtroom, guys. Um, y'all see my beautiful daughter? It's my baby. She's turned 3 years old. I love her to death. She's amazing. She's beautiful. So happy. So blessed. See? See, so now even with that turned all the way down, it's really loud. So I gotta turn down this bad boy. Yeah, you could probably hear the audio a little bit. All right, let's get back over to my boy. Nothing. Nothing's moving. Nothing is moving. So, let's chit chat for a little bit. Yeah, I need a new mic. I'm not gonna lie. I need a new mic. What do you mean now my mic sounds low? Oh my god, I'm done with y'all. Well, I'll just mute the music then. Do I have to register a financed van? What would make you think that you would have to register anything? You're a living being. It doesn't matter if it's financed or not. We're doing good, Frank. How about yourself? They're moseying around, but they ain't doing much. I'm gonna be surprised when they find out that we found out who we really are and that they ain't got no power over us. But they knew that already. They just wanted to play us like dummies. What y'all got going on? Car dealers have a contract with the state. Read the financing agreement. The bank technically owns it. I'll throw the chat over here so y'all can see what y'all are chatting about on the screen. Let me move my big old head. Y'all could see on the screen what's being chatted. I like OBS. I guess it's working out okay now. It used to not. I used to lag, but I changed some settings. What's up, Nubs? Let me see where Luis is at. I wonder if we can call Luis while, cause he ain't in the courtroom yet. Oh God, I'm all over the place. Is that him? Oh, he's walking out the courtroom. I see him. Hey, I just wanted you to come on and say hi to everybody real quick because they haven't started yet. Well, come on camera and say hi. Put your face on camera. Put your face on camera. Just turn around the camera. It's all. Yeah, say what's up. Yeah, you're live. Okay, look, say hi, everybody. Okay, okay. Tell them how before they start. Tell them how you traveled across the nation and didn't get stopped while you was on private plates. Oh wait. Sorry. Okay, go.
I just ended up getting some ordering some other plates that were at the same website I got it from before, and then I just ended up slapping them on the truck, and yeah, I just continued to go my way all the way to Virginia,
It's
and
right.
then
You didn't
from
let nothing
Virginia.
stop you, huh?
Oh yeah, no, nobody stopped me. Like I was staying at Walmart's and stuff because we were pretty much made the truck into a like a little sleeping area.
Yeah.
And then yeah, and then we ended up going to DC as well, and over there to the inauguration where where it's super packed, the
Yeah.
FBI
Yeah.
and all these different CIA and different agents everywhere.
Yeah. Our servants.
Yeah,
Yeah.
yeah, exactly. Yeah, so but yeah, it was pretty nice to be able to travel all the way down there again. It's like my second time going down there in the truck.
Yeah, so again, you went all the way from Washington to DC and back
Yeah,
with private
35
plates.
hours, 35 hours one way, and then yeah, so
Yeah, so I
yeah,
just want everybody to know this dude is the real one. Okay. Oh, they're getting in there talking, Luis. You better go. I hear him on the audio.
yeah, all right,
All right,
cool.
Papa. Bye.
Yeah.
So as y'all see,
This no contact order was handed to you earlier, Your Honor, and no, it is not signed by the defendant. And I wanted to give the court an explanation and see if we can still move forward. There's already an existing order.
This is Kyle Patrick Sather Tiersma. He was on.
Sorry, this was not on the docket this afternoon. This is just a document.
Well, I know, but if we're gonna have a hearing on it, we need the minute in the file.
Yes.
So,
All right.
no,
Apologies.
do you need the file or do you just want it? It was already on the docket this morning. Okay, so we'll circle back to that one.
Okay.
Um,
I think Miss Haney's right then.
all right, Miss Haney.
I just have a question, Your Honor.
Okay, who do you have?
Miss Whitney.
Okay, good afternoon, Miss Whitney. She is here in cause number 24-1-249-33. Does not look like plea paperwork.
It is not, Your Honor. We are super close, though.
Okay.
Mr. Luchin and I spent at last 15 minutes talking about this, but we want to check with victim first before resolution. So we're asking him to tomorrow afternoon at 1:30, hopefully be able to.
Oh, okay. And we're still well within speedy because it looks like trial's not till March 19th. And Miss Whitney, can you be back with us tomorrow? Okay, perfect. And then Mr. Luchin has signed off on this, so I'm assuming it's agreed. Anything else we can do for Miss Whitney, Miss Haney?
Thank you.
And then Mr. Luchin, anything on Miss Whitney's matter, just moving this to tomorrow afternoon? Okay, all right, so I'll see you tomorrow, Miss Whitney. Thank you. Is Derek Buckman present? Paging for Derek Buckman. If Mr. Buckman's on WebEx, please press *6 to unmute. No response from Mr. Buckman. Mr. Luchin, this was a summons to appear on a harassment threat to kill.
It is, Your Honor, and I would.
okay, I'm testing. Oh, I figured it out, y'all. Well, I figured out the mic issue. There we go. Testing. There we go.
Yes, please. Okay, so I've got an order in Mr. Rathman's matter.
Hey, I just want all of y'all to know, um, in relation to any emails that y'all may have sent me or anything like that, I'm gonna get to them, y'all. It's not like I'm trying to. I'm getting very stacked up. I'm not gonna lie. It's been it's been pretty bad. I've been getting so swamped that it's getting hard for me to keep up. We have 27 different cases or 27 different people that we're working on exclusively in the Discord. Luis is one of those 27, and it's just growing every day, right? Because again, we're doing everything free and for the people.
Yes.
So as we're doing all this free,
Miss Torano, you are calling in and
you
holding
know,
for
it's
the
it's
better.
it's it's a lot of work, y'all. I ain't gonna lie, especially when people don't know what they gotta know, and then they asking you all the questions. So, if you send me an email, I'm gonna start getting back
And
to
is
him
holding
tomorrow.
good for
Today, I
both.
have one
All
more
right,
other
good. We'll go
appointment
after
as
him
far as
right
real
after
world
he
appointments
gets
that I
back,
have to
please.
attend. Um,
So this is
so I'm
booth
all the
number
way.
2413533.
I'm all the way on the West
Looks like
Coast,
Miss
so it
Torano's
is kind of
enrollment
hard,
status
for.
based off of
I'm
data
always
positioned
later
by
than
myself
everybody,
on the
but
January
I work late too.
14th.
Um,
Miss George, have you
so
had
just
any
know I'm gonna get back
promotions
to you,
or
AK. I
promotions?
promise, brother. I saw you in my emails. I'm actually catching up. So I'm very
Is
excited
the
about
state
getting
of both
catch
of
up.
your
I'm
requests at
less
this
than
point in time?
15 emails right now that I gotta answer back to. The Instagram's just gonna have to wait. I'm sorry. I used to be able to answer every comment on YouTube, and I did that for a good month and a half, but I just can't do that anymore. I used to answer every comment. Um, but we got the traffic law reform at what's up, Woodinville, WA Douglas. We did get the traffic law reform signed to 1,000, and that's amazing because now we're about to send them off all over the place, and we're about to really get in there and start speaking all over the nation. Um, I mean, all over. We're gonna start setting appointments, really getting these in front of their faces, the petition, and it's just gonna span from here. Hopefully, pretty soon I'll be able to quit my day job if we can get enough support through the YouTube, through ads, and then just maybe community support through everybody to really go out and help people individually and start doing documentaries. That's a big hope for mine. For myself and this channel and this foundation, we're going to turn this into a real nonprofit organization and foundation as well. You already know it, you can see it, and we got a lot of heavy hitters. I know my boy David John's in this bad boy. He's a heavy hitter. He knows what he's doing. He's got some amazing stuff working. We see Luis right here with his family working in the back end very heavily. All three of them, all three, you know, his whole family's there supporting. You can see him in the back. We got a lot going on, y'all, and I'm just so stoked. I'm so happy for this movement. I'm so happy for the traction. I'm so happy for the positiveness. I'm so happy that we're putting God at the forefront again, our great creator, because we've been going through so. What's up, Tri Cities? Who's in Tri Cities? You in Tri City, AK artist? I need to come over, bruh. If you're not in Tri Cities like Richland, Kennewick, and all that, cause I'm about to be over there. You can come meet me tonight, bro, if you want to. Um, yeah, if you wanted to come in, private member association. I don't know, man. I don't know, but I see you in here, tribe. We'll have to talk about that. The only thing with the tribe, listen, I like the tribe, y'all. Tribe's very smart, but this guy will not come into the Discord or phone conversation. He's so weird. He'll be on YouTube, but he don't want to come in the Discord. Come on, man. You gotta come in the Discord or come on a Zoom call. We got one coming up on Wednesday, y'all. AK Audits in Tri Cities, man. Well, if you want to come through tonight, man, let's meet up. I'm gonna be at the American Legion. You dig? I will be at the American Legion tonight at 6:30 in Pasco, Washington. I got a job over there I'm bidding, and they're supposedly supposed to be getting me dinner to come over and finish up that bid and job. So, but we'll also be talking about a lot of freedoms and things as well. Only private. I hear you. I hear you, tribe. Well, you're not private right now on YouTube, are you, buddy? So, but yeah, I think everything that we're doing is growing exponentially. I think if we have a lot of hard hitters that come to help to really speak, I think things are going to change. I know they're changing. They're already changing right now. If we utilize a lot of the things that are already out there, such as the New Hampshire bill that we just seen to initiate change and introduce bills all throughout the United States and get some real action, that's going to be phenomenal. I don't think it'd be too hard to draft up another bill very similar to what New Hampshire already has. I mean, we could literally just copy that bad boy almost word for word, or put some legalese in there in which we think that's going to be best suited for our communities. Um, but I'm very hopeful for today to see this dismissal in relation to Luis's situation. Um, this one's a big one, y'all, and we're over here doing victim advocate. I see somebody's in the webinar as victim advocate. Yeah, because the victims here is not the state. The victim is Luis and his family. Um, I almost want to open back up their chat again. The constitutional violations here are egregious and irreparable harm has already been done. Jeez. They're cooked, man. They're cooked. They're cooked. They're cooked. Let's see. I gotta get the chat back on top. So this is kind of exciting. I have a little bit of anxiety. I'm not gonna lie here, y'all. I got anxiety in relation to the decision that they're about to make. Uh, yeah, I got anxiety, but I don't at the same time because we already know we got action. We can go ahead and hit them with the injunction later. We've got so many different actions that we can move forward with. I'm wondering if Luis is going to hit him with the disqualification if they don't rule in his favor. I'm wondering just what he has because he has so many different aspects and avenues. Yes, people versus battle is the best. He has so many different aspects and avenues in which he can move the court on his behalf. I just wonder which route he's going to take in and of itself. And I guess now maybe what I should do is move the mic up just a little bit more. I'm not sure. Well, try John. I think it's John.
Okay.
I think you're John. I think your name's John. John, you just need to come in on this Wednesday then on our Operation Wise Dome in the Zoom at 6 p.m. Pacific Standard Time. And I know you said you was over in Florida, but come and tell us about it, bro. Real talk. If y'all ain't subscribed to the tribe, he's right here in the chat right now. Dude is like on point. He really on point, y'all. And he be diving in deep on some stuff. Now we had a meeting last week, and he really confused me even more than what I should have been confused. But I was already confused within myself because I didn't realize that the federal complaint that I have currently open against, currently active against Hood River Police Department, the city of Hood River, and 3 police officers. At that point in time, when I was talking to him, I didn't even realize that it was the actual answer. I'm over here thinking it's a motion to dismiss, bro. And then I finally realized that it's not a 12B motion to dismiss, and I'm like, oh my God, they answered me back, bro. Like, I got full action. So, yeah, I'll probably be going over some things this week. I got to file some things, actually, this week, because I only have 21 days in relation to filing my amended motion, but I do. Then we got to do a flurry of motions. We just got so much that we got to take care of that I want to run y'all through. But this isn't about me right now. It's about Luis, but yeah, we're moving forward. We got to answer back. So we got action. And then Luis, I think Luis is wanting to wait.
Serrano, anything else we need to do for Ms. Cook this afternoon?
I'm thinking Luis is wanting to wait in relation to his civil suit until he just kind of gets this taken care of and out the way. But, yeah, Luis has got a huge civil suit ready to go. Or, we ain't started developing yet, but he's got a big one. This is huge. This is definitely irreparable harm. They may have sold the vehicle already that they towed, and if that's the case, how do you get that back? What kind of process does that look like? That's a very lengthy process, and that's irreparable harm for real. So let's listen into the court for a little bit, see what they got going on.
Okay. All right. Well, we hopefully will see you in person tomorrow.
Fingers crossed. Thank you, Judge.
All right. Thank you, Mr. Reno. All right. So
Okay.
we do have the file for Mr. Sather Tiersma. This is 24-1-331-33. Again, so what are we?
What's up, Shadow? Or what's up, Shannon?
Civil no contact order as well, and in that the AV came and asked to have this one amended because she declared that they were not partners who had ever resided together. So they changed that box as all, but the conditions and the material substance of it did not change in any way. And I will assure that my client gets an updated copy of this, but the contact portions and manner in which the restrictions are in place did not change at all. And we were supposed to have dealt with this morning, and it was an oversight by both counsel.
So we're removing the findings that this is a DV no contact order?
Correct, just a no contact order.
And the state's okay not having Mr. Sather?
The state's the one who drew it up, presented it to me, and I was fine with it since there was no material change in that regard. It actually reduced any what would be restrictions
Mr.
on him.
Richard's already gone. Is there any reason this can't, I mean, this is gonna subject him to arrest. So when law enforcement see this and doesn't have a signature on it, I think that's gonna cause further complications. Can this not get handled on the 10th when he comes back?
I was presented with it, presented to you, and I was the one who was just directing the court that I didn't have an issue with providing him a copy and noting that his attorney's present. But if they want his signature, then.
If this was civil, yeah, if this was civil, we could totally do it on your signature alone, but with criminal, for it to be arrestable, it's gotta have his signature on it.
Then we'll have to push it
Okay.
over.
Just
And
hand it back. We'll.
All right, so Mr. Kevin, Grady, if you can give that back to Miss George. Okay, so, perfect. Okay, we've also got the Greenan matter on when there's a request for a motion by the protected party to quash the no contact order. Sir, if I can have you come up to the microphone, please. And then Miss George, did your office get notice of this?
We have I have it in my file, so we must have.
And I don't show that notice was, well, Mr. Carmen's already downstairs. So
I also can tell the court that we got a substitution with Mr. Duggan. I got a notice of appearance and discovery demand that's filed January 21st. But as far as if Mr. Duggan had planned on appearing or anyone else, I don't have any information on that.
Okay, so Mr. Olson, did you provide notice of this hearing to anybody?
The prosecuting office downstairs.
Okay, did you provide notice to Ms. Greenan's new attorney, Mr.
I do
Duggan?
not know of the screening's attorney's name.
Okay, because this could result in basically a modification of the no contact order instead of an outright dismissal. So it's proper to give everybody notice. Our next hearing in this matter is not until March 3rd. I'm assuming that this is not something that can wait till that point in time.
Prefer not to.
Okay. Are you able, if we gave you Mr. Duggan's contact information, to provide him notice, say by next week?
Of course.
Okay. So
Also send Mr. Duggan an email if the court would like. If we pick a time where we're gonna move it to.
okay, so would you be available next week at 1:30, Mr. Olson?
I will, yeah.
And are you living here locally, or are you in Chihuahua?
Chihuahua property.
Okay, we'll give you the information to call into court, so you're not driving up here just in case something doesn't happen. So Miss George, could I can do do you have just
I
a,
have one too.
okay, thank you.
Sorry, I started multitasking. Can I have a simple continue? Oh, never.
Mr. Olson, do you have something to write with by any chance?
Thank you.
So the attorney's name is Matthew Duggan. It's Duggan.
Okay.
And his phone number is 509-557-0584.
Okay.
So I just give him a call and just give him at least verbal notice, and then it sounds like Ms. George will follow up with an email.
Just let him know that this has been submitted.
Yep, and then he'll probably want to see a copy of it. Let's have Mr. Olson sign too. We'll just change this.
I do have a copy, so if I need to scan or email.
Okay.
I can attach it to an email to
Mr. Olson can just sign off on that. Yes, please. Yep.
You have an email address actually?
Yes, it's Matt.
Oh, no, I mean, do you have an email address so I can CC you?
You want my email address?
Mhm.
Yeah, DONARIO
ARIO
at Gmail.
at Gmail?
Yeah.
Okay.
Thank you.
Donario.
That's correct.
Okay, I'll send an email as soon as I get out of here and CC you on it so you can see what I send him regarding this.
And will that include the information
I'll
for
just
next Monday?
scan this in,
Oh,
yeah.
okay.
Yep. All right. So Mr. Olson, I've signed off on this and then we'll see you again next Monday at 1:30 or at least talk to you on the phone. All right. Thank you, sir. Okay, so that leaves Mr. Luis Armando Ochoa Ibarra. Good afternoon. And this is cause number 24-1-332-33. We've got a note for hearing on a motion to dismiss. And is that the most recent one that you filed? Because there was 3 that were filed at different points in time.
This one was received on the December 31st.
Okay, so that's the one we're talking about today. Okay, and then Mr. Christensen, your prior NAPSTAD response is your response to this one, or is there supplemental briefing coming?
So do I understand the defendant is withdrawing his prior motions to dismiss? Because I've got several of them.
Yeah, well, I put in them that I can amend it. So this is the last one that I amended.
I guess so. For my purposes, when I went through the one that was filed on December 31st, the issues that I'm prepared to hear argument on and address is that there was no valid legal predicate for a threat of arrest under RCW 1031-100. That was your first argument, correct? The second one is that you believe that based on the evidence that has been presented to this point, that the forgery charge is essentially fabricated out of non-existent authority.
Yeah, there was no ill will.
Okay. All right, the third one is that there's prosecutorial misconduct in the filing of the charge. Then I've got prejudicial labeling of an ideological profiling based on Sergeant Swim's references to you as a constitutionalist. Violation of due process and fair notice, which is kind of relating back to the forgery charge.
Yes.
And then prosecutorial misconduct and overreach, which again, I think is just tied back to that forgery charge, correct?
Okay.
So those are the issues that I understand are before me, Mr. Christensen.
Very well.
Okay, and so are you ready to proceed on those?
Yes, sir.
Okay, and then we were also set on this morning, for omnibus and a status conference. So we'll address the motions to dismiss first, and then we'll turn back. We'll see what the outcome is there. So I'll hear argument from you. Mr. Christensen is not going to interrupt or anything like that. Then he'll have a chance to argue.
For obstruction, for not giving up my information when it's my Fourth Amendment protected right. You can't go against and violate the Constitution. When it specifically states that you can't, you don't have to give up. Well, it's unlawful searches and seizures, so that includes your name. To the right to be private. In your person. He ended up after threatening me with arrest, and I verbally gave him my name, and he was actually just gonna charge me for failure to register. And my wife asked him like, why are you, why are you trying to ask him for his information? He's like, oh, it's because he doesn't have a plate on his trailer. So under RCW 1031-100 is specifically states that there has to be an injured party, and there has to be probable cause in order for him to arrest me without a warrant, and there wasn't any of those. And he also I just that but what's his name, Swim, like later came on the scene, and right away he started labeling me a constitutionalist and a sovereign citizen. And I don't know why he even started saying that when he actually takes an oath to uphold the Constitution. So for him to be saying that is not right. It's like he's actually going against the Constitution, and that's treason right there. Let me see. There's also Swim ended up as well going and fabricating a forgery charge. Lee was even saying like, yeah, I can see that if it was a fake trip permit that was forged, but there was no forgery at all. This was just my personal plate that anybody can order online. Anybody can order a plate online and custom make it as they want. So it wasn't something that I just made myself, and I didn't intend to cause harm or injury to anybody. There was no ill will. I was just going by let's see. I was going by this. Yeah, so I was going by Murdoch versus Pennsylvania. That it states that although it may make tax the proper use of the income derived from that commerce, so long as the taxes are not discriminatory, the case cited a license tax applied to activities guaranteed by the First Amendment would have the same destructive effects. It is true that the First Amendment, like the commercial clause, draws no distinction between the license tax, fixed sum tax, and other kinds of taxes, but that is no reason why we should shut our eyes to the nature of the tax and its destruction influence. The power to impose a license tax on the exercise of the freedom is indeed as potent as the power of censorship, which this court has repeatedly struck down. And also, they claim the following examples of Paul, which this was in scripture in the Bible. Says that Paul publicly from house to house in Acts 20:20, they take literally the mandates of scripture, go ye into all the world and preach the gospel to every creature. Mark 16:15. In doing so, I believe that I am obeying the commandment of God. Also, a state may not impose a charge for the enjoyment of the right granted by the federal constitution, since the privilege is questioned and is guaranteed by the federal constitution and exists independent of the state's authority. The inquiry as to whether the state has given something for which it can ask the return is irrelevant. Also, Shapiro versus Thompson is another one. Since the freedom of travel is a constitutional liberty closely related to the right of free speech and association, we believe that appellants should not be required to assume the burden of demonstrating the Congress could not have written a statute constitutionally prohibiting their travel. So that's the reason, one of the main reasons why I didn't have a plate on my trailer, because I'm practicing this right that I have, and also on my truck, I have the right to be private and not have a state plate, which they issue a license and a fee to practice a right. Um, also, let's see.
My
And
boy
also
ripping.
these officers cause irreparable harm, not just to me, but to my family, my children. They confiscated my truck, my trailer, my flatbed, without probable cause, and they caused, well, definitely irreparable harm. It, there's no way that there are no monetary fund that can be able to fix this, especially how my children were, they pretty much were like crying throughout this whole time, knowing that their dad was standing up for his rights. Also, I was, just practicing my rights under the First Amendment, the Fifth Amendment, the Ninth Amendment specifically states that, just because a right is not specifically mentioned in the Constitution doesn't mean I don't have that right. Murdoch versus Pennsylvania, which we just went over, constitutional law, second-hand jurisprudence, and let's see.
It's on the record. Irreparable harm.
Also, there was RCW 4655 113 says that the Washington State Supreme Court recently decided in State versus Villela, oh, yeah, Villela, that the mandatory impoundment component of the statute violates the state constitution. In coming to this conclusion, the court determined that the Constitution requires that the arresting officer make a discretionary determination that impoundment is reasonable and that there are no reasonable alternatives to impound. My wife was there. She could have easily taken the truck so that they wouldn't have left us without um, any means of travel. My children and my wife were stranded. We recently moved up here not too long ago, so we had to try to figure out who can pick us up. This, I thought that police were there to serve and protect, but yet they caused irreparable harm. Uh, they also, violated so many parts of the Constitution, even under the 10th Amendment, that you know they if their laws are not specifically mentioned in the Constitution, then they can't go outside of that, and they definitely went outside of that. See.
I love how he's taking his time, being calm. Nobody's rushed. He knows what's up. This is his time. He called this hearing. This is
There's
his
this one
hearing.
as well. It says that if an arrest by a constable is in its inception wrongful, all other constables who act and assist in the continuance of wrongful imprisonment are responsible for the entire damages thereby caused to the plaintiff, although they had no knowledge of the unlawfulness of the imprisonment and intent of act in strict charge of their official duties. They lost all immunity. I can personally go after them for violating the Constitution. They have no immunity. 69 jurisprudence, second, uh, section 177, late second edition, section 256. There's a general misconception in that any statute passed by legislator bearing the appearance of law constitutes the law of the land. The U.S. Constitution is the supreme law of the land, and any statute to be valid must be in agreement. It is impossible for both Constitution and a law violating it to be valid. One must prevail. This is succinctly stated as follows. The general rule is that an unconstitutional statute, though having the form of and name of law, is in reality no law, but is wholly void and ineffective for any purpose, since unconstitutionally dates from the time of its enactment and not merely from the date of the decision so branding it. An unconstitutional law in legal contemplation is inoperative as if it had never been passed. Such a statute leaves the question that it purports to settle just as it would be had the statute not been enacted. Since an unconstitutional law is void, the general principle follows that it imposes no duty, confers no right, creates no office, bestows no power or authority on anyone, affords no protection, and justifies no acts performed under it. A void act cannot be legally consistent with a valid one. Non-constitutional law cannot operate to supersede any existing valid law. Indeed, insofar as a statute runs counter to the fundamental law of the land, it is superseded thereby. No one is bound to obey the constitutional law, and no courts are bound to enforce it. Also, it also states that any, it says Cooper versus Aaron, 358 US 178 as CT 1401 1958 says any judge who does not comply with the oath to the Constitution of the United States or is against the Constitution and engages in an act in violation of the supreme law of the land. Judge is engaged in acts of treason. The U.S. Supreme Court has stated that no state legislator or executive or judicial officer can war against the Constitution without violating his undertaking to support it. And it also states in Title 42 USC 1983, which provides that anyone who, under color of state statute, regulation, or custom, deprives another of any right, privilege, or immunity secured by the Constitution and the law shall be liable to the injured party. There can be no doubt Section 1 of the Civil Rights Act of 1871 was intended to provide a remedy to be broadly construed against all forms of official violations of federal protection rights. I also told Swim that he was violating my rights under Title 18 242, which is stated on my plate, and he's like, "Oh, why don't go off the titles?" But obviously he's going against the Constitution, which that title actually brings up. And also the fact that that Fellner lied on his police report under penalty of perjury, and also Christensen also affirming that on that police report that he was confirming whatever's on there under penalty of perjury, knowing that Fellner actually was making stuff up from the beginning about saying that he noticed my plate was not not part of that was already pretty much forgery. Let me see exactly how he stated it. Okay, so it's right here. It says, so this is what he said verbatim. I noticed what appeared to be a false plate mounted on the bumper of his truck where a real plate would go. It looked like thick plastic and said State of Washington at the top of, and had a number of 077 Yall. Under that, it said Title 18 242. So I stated that if Fellner noticed this, then why was he only going to charge me or first write me up for no registration and never brought up my plate? The only time he ever brought it up was when Swim came along. Then that's when they started to conspire under Title 18 241. It says that Fellner should have let me go after threatening me with arrest without probable cause, because after Fellner threatened me with arrest, my wife asked him why he needed my information, and he said, I quote, "Because the trailer got no plates on it." That alone was a traffic infraction, not a crime, and was not a arrestable offense, as stated in RCW 1031-100. I do have that RCW as well. That states that. Okay. Yeah, so it's in RCW 4616 .030, or yes, 4616A 030. It says registration display plate required penalty expiration registration impoundment. And it says in number 4, it says failure to make an initial registration before operating the vehicle on the public highways of the state is a traffic infraction. So he didn't even have a reasonable articulable suspicion or any probable cause to arrest me or even threaten me with arrest, which was definitely a threat and harassment. There was so many other things that this caused as well. And also that there was no ill will. Like I definitely would not intend to defraud or cause harm to anybody. I'm a Bible believing person that I go by what the Bible and what the Bible says alone. And and for me to be able to go out and preach the gospel, and do what I need to do without being infringed or held back from practicing the right is what the Constitution actually protects. Also, there was even in the charge alone of forgery, there was a lot of ambiguity, which would fall under the rule of lenity. And also, let's see this one right here. Yeah, from the beginning they had they were just it was all presumption. They're presuming certain things without even having the facts. And they just wanted to arrest me. They even said themselves, oh, I would love to see this guy arrested. So there was ill will in their part. There was definitely a lot of evil intentions on their part. Also, there was another thing that I found in RCW 4601. Oh no, let me see, that's not it. I found it at 40. Yeah, so it's RCW 3675 010. Which is the definition of highways: every highway, lane, road, street, boulevard, and every way or place in the state of Washington is open as a matter of right to public vehicular travel, which was what I was doing. It's open as a matter of right, not open as a matter of privilege. It's definitely a right to that for public vehicular travel, which was what I was doing. Uh, from what I've been studying Black's Law Dictionary and stuff as well. The definitions of driver is actually one that's employed. Definitely was not for hire. Wasn't employed. Which I understand that is a privilege to drive. But I was definitely not doing so. And also just the fact that all these other ones that the state can't charge a tax, license plate tax to practice it right. And I definitely am the express intended beneficiary of the Constitution. So the state only has certain certain right, and if it's not expressly stated in the Constitution, then there is no right outside of that, as the 10th Amendment states. Even police powers also states that it has to be within the Constitution. So I do. Let's see. Let me make sure I didn't miss anything else. Also, they ended up impounding my trailer, and I was trying to get it back. They said since it wasn't registered that they were going to sell it, and so they actually ended up selling my trailer, violating my due process, um, especially because it was taken without probable cause. There was no crime committed in the first place. They also did an unlawful warrant on searching my vehicles as well, without probable cause. Um, and just the fact that Officer Sun did display a bias when he first entered. This is the first thing he came up to me and told me, and he started labeling me a constitutional and a sovereign citizen. The characterization constituted prejudice, um, contributing to an environment of hostility and conspiracy against me. Instead of addressing my lawful inquiries regarding his authority, Officer Fellner attempted to charge me with obstruction for merely questioning his demand for ID without proper justification. So, there was that exhibit that I ended up putting in, which was yeah, Officer Fellner's body cam footage was just stated, exactly what was on there. I just put whatever he said verbatim on there. And then the Declaration of Probable Cause, it says under penalty of perjury, the laws of the state of Washington, the undersigned hereby declare that I am a deputy prosecutor of this country and make this declaration in the con- capacity. I am familiar with the police reports and investigation conducted on this case. If the prosecutor was familiar with all of this, then he should have actually looked at the body cam footage and noticed that it didn't match up with what Fellner was stating. He inserted certain things that didn't even happen until later, uh, when Swim actually arrived, when the conspiring started. Even Fellner said that, like, do we really have to take it this far? And go to, oh well. Oh yeah, so I just wanted to read this as well. It says hospital law review. It says unless an actor confesses with his intent, proof of this element must be supplied circumstantially by inductive inference. There are many varieties of rebuttal of intent, some of which resemble the shop boss's denial of purpose or knowledge, and some of which take other approaches. Meanwhile, although the word intent sounds clear and often is treated in the law as though it were any appearance of clarity. Wait up. Okay. Yeah, which takes the approach. Meanwhile, although the word intent sounds clearly and often is treated in the law as though it were any appearance of clarity dissolved in real situations such as the one previously described, there are many meanings of intent and the outcomes often depend upon which meaning the decision maker consciously or consciously or unconsciously adopts. In the model penal code jurisdiction, the definition of intent requires proof that it was the actor's conscious desire to engage in that questioned conduct or to cause the relevant result, which I didn't have ill intent and it still has not been proven. I actually stated my intent on here and backed it up with case law and the jurisprudence and other constitutional laws as well. So there was definitely no ill will. Just, and just the prosecutorial misconduct and overreach. I stated a few RCWs on there. Like RCW 96210 says malicious prosecution. Every person who shall maliciously and without probable cause, therefore cause or attempt of another to be arrested or proceed against for any crime of which he or she is innocent. If such crime be a felony, is guilty of Class C felony. We'll just state that. And then there's RCW 9A 4620. It says on A, without lawful authority, the person knowingly threatens, which was definitely my situation. And then I think that's two, to cause physical damage to property of a person other than the actor or to subject the person threatened or any other person to physical confinement and restraint, and maliciously to do any other act which is intended to substantially harm the person's threat or another with respect to his or her physical health and safety. They did that to my children and my wife. They definitely threatened their physical health and safety by leaving them out there like that, knowing that there was other ways of not having to impound my vehicle, that she could have easily taken it. The one that was previously registered to was her father. They both have the same last name. They could have easily just allowed her to take my truck and my belongings. That and then RCW 972-020, perjury. It says a person is guilty of perjury in the first degree of any official proceeding. He or she makes a materially false statement which he or she knowingly knows to be false under an oath. And they also took my automobile, and not with knowledge of the fact that the automobile or motor vehicle was unlawfully taken. They definitely don't have. There is no. Yeah, the RCW 9A8010 says official misconduct. A public servant is guilty of official misconduct if with intent to obtain a benefit or deprive another person of lawful right or privileges, he or she is intentionally commits an unauthorized act under color of law. It was definitely under color of law because they violated the Constitution. He or she intentionally refrains from performing the duty imposed upon him or her by law. Yeah, so I just that's about it. I just want a motion to dismiss for this frivolous case that I'm a part of, and there's also the relief that I was asking for. Dismissal of charges with prejudice. The defendant respectfully requests that all charges against him be dismissed with prejudice for the following reasons: the threat of arrest and the arrest itself conducted without a warrant violates RCW 1031-100 and the Fourth Amendment to the United States Constitution. There was no probable cause established, harm, threat, or statutory justification to intrude upon the defendant's private affairs. Additionally, Officer Fellner falsely claimed that not having a plate on the trailer was a crime, whereas RCW 4616A30 classified it as a traffic infraction. The arresting officer acted beyond lawful authority by engaging with the defendant on private property not involved in traffic without legal cause, statutory compliance, or adherence to required procedural safeguards. The misapplication of statutory authority, coupled with the escalation of circumstances by law enforcement, demonstrated unreasonable and prejudicial conduct violating the defendant's rights under Article 1, Section 7 of the Washington State Constitution, which provides heightened protection against unlawful interference with private affairs. I also asked they suppress all evidence. They also took my, what was it? My title. They were looking for an ID or whatever, and they ended up taking other things that wasn't even a part of what they stated they were going to take. The defendant requested that all evidence obtained as a result of the unlawful arrest, detention, or engagement be suppressed as inadmissible under the doctrine of the fruit of the poisonous tree. This is consistent with the exclusionary rule established under constitutional law. As such, evidence was obtained in violation of defendant's constitutional rights. Compensation for damages. The defendant seeks just compensation for damages suffered due to the deprivation of rights under color of law pursuant to 42 U.S.C. Section 1983. This includes, but is not limited to emotional distress suffered by the defendant, his wife, and 3 children, reputational harm, financial hardship, and other consequential damages stemming from official misconduct, harassment, and unlawful actions such as unlawful impoundment, flatbed trailer loss, funds used to reclaim truck and car that God-fearing brothers impound, and of course, irreparable harm. Judicial recognition and preventative directives. The defendant requests that this issue finding recognize the procedural and constitutional violations inherent in this matter and provide appropriate directive to ensure that such unlawful conduct is not repeated by law enforcement. This safeguards the right of all people under the United States Constitution, the Washington State Constitution, and other applicable laws. The defendant expressly reserves the right to amend. Well, this was just stating that I have the right to amend it. The community petition. The defendants also provided petitions signed by over 121 individuals. There's probably more now. There's a website reflecting public concern over this prosecution. While not determinative, this exhibition underscores that These violations of individual rights are of significant concern to the community at large. And the conclusion for this reason, as set forth, the defendant respectfully requests that this honorable court grant the motion to dismiss of all charges. The unlawful threat of arrest, devoid of any factual or legal basis of the crime, constitutes a profound infringement of the constitutional rights. Perjury, falsifying a police report, the prejudice labeling. Such conduct is intolerable in the system committed to justice, due process, and accountability. By upholding the defendant's constitutional protection, this court reaffirms the cornerstone principle of freedom and fairness that animates our legal system. As Thomas Jefferson observed, when the people fear the government, there is tyranny. When the government fears the people, there is liberty. Dismissing these charges sends a clear message that unjust powers, fabrication of offenses, and prejudicial approaches have no place in our court. The defendant's liberty and dignity must not be sacrificed to unchecked authorities. The court's intervention ensures that we, the people, endure such treatment, preserving constitutional integrity and ensuring justice for all who stand before the law.
All right, thank you, sir. Mr. Christensen, what's your position on this?
Mind if I remain seated?
Yes, no, go ahead.
Yeah. First of all, Your Honor, there's a few factual differences that I have with the defendant's factual inaccuracies and what he's presented. First of all, the defendant was arrested on October the 6th of last year on 4 charges. One of them is a forgery for having a fictitious license plate mounted on his vehicle. He was also arrested for obstructing law enforcement for repeatedly refusing to identify himself, provide his driver's license in violation of state law to law enforcement, and repeatedly arguing with them that he was not required to have his vehicle licensed. He wasn't driving, he was traveling, and that somehow exempted him from state law. He was also charged with failure to transfer title on the vehicle within 45 days as required by state law, and with refusal to give information to law enforcement officers. I won't go through all of the facts in the case as they're included in my brief. There's Detective Feldner's narrative, which lays forth each and every one of these charges, as well as the facts underlying it. So I won't waste the court's time with repeating that, but I would ask the court to consider it. It lays out a very compelling case for each one of these charges. Once the defendant was arrested on October the 6th, he was booked on those charges, and he had his first appearance in front of a Superior Court commissioner the next day on October the 7th. The Superior Court commissioner read Detective Feldner's affidavit, and he found probable cause for each of the offenses listed in that affidavit. The next day, on October the 8th, the information was filed by my office, including those charges that the commissioner had found probable cause for. So I would definitely dispute any kind of an allegation of prosecutorial misconduct or inventing charges. All of these charges are documented in Detective Feldner's affidavit. The Superior Court found probable cause for them. We simply filed those charges. The defendant has filed a great number of documents in this case, repeated filings of motions to dismiss, various other documents, threats against the officers, allegations of crimes committed, threats to jail the state's attorney, things like that that show what his ideology is here, the reason that he's doing what he's doing, the reason that he argued with the officers on the day in question.
Objection.
Hang on. This is argument. What's the objection?
I'm just objecting to, it's all hearsay what he's saying, and then just the fact about the whole court hearing. I have also things in there stating that what Swim ended up saying was all, he lied on the penalty of perjury in there as well. And they weren't allowing me to say anything in there.
I'll overrule that because Mr. Christensen's not testifying, so hearsay only applies to testimony. This is just argument based on the briefing. So, no, you're okay. Go ahead, Mr. Christensen.
Your Honor, on October the 11th, the defendant filed his first demand to dismiss the case, entitled a motion to strike and dismiss. He claimed there was no corpus delicti. He was not operating a vessel in commerce, various other quasi legal theories. He also filed a memorandum on October the 14th, again, reiterating the argument that he made to the officers in favor of not having to register his vehicle, not having to provide identification, that is, this right to travel. And he also filed the last 3 pages of that was a notice of liability, which accused the state, the officers, the sheriff's deputies of committing trespass and treason and mentioning penalties that they may face. On November the 4th, he filed another motion to strike, dismiss, and noted a hearing where he rehashed a number of the same arguments. At this point, the information had been filed. The matter was properly in front of the Superior Court, so the state did file a response on November the 7th, pointing out that the defendant was properly within the jurisdiction of this court. It was alleged he committed crimes, violations of state traffic law, as well as the forgery counts, and pointing out that the laws that he was citing, the quasi-legal arguments he was making, were not founded in Washington law. And his motion to dismiss was denied by the Superior Court. He had also filed a couple of additional documents, a reply doubling down on his use of the Uniform Commercial Code and claiming a lack of evidence. He also filed a quote-unquote statement of facts, wherein he name-checked myself as well as Detective Feldner, Deputy Smith, Sergeant Swim, Deputy Lee, all Stevens County Sheriff's officers. And he accused us of violating his freedom to religion, as well as discussing at some length perjury, false swearing, apostasy, evil, corrupt judges, all of this to avoid complying with traffic laws and state criminal laws of general applicability.
I wasn't avoiding traffic laws. I just showed it like my intention. So
And again, this is argument. So he's entitled to leeway. You had your argument that you don't believe that your vehicle needs to be licensed by the state, your reasons for it. He's presenting his reasons why he believes that under the state law, these charges are justified. So there's latitude the court gives folks in argument. I'm sure there was things that Mr. Christensen did not agree with you when you made your argument and he sat. So, I mean, unless there's a specific misstatement of fact in this case, that's not something that he's testifying to.
that would be a misstatement of fact.
This is argument. So nobody's under oath here. You made your argument. This is his argument. Literally, this is everybody's pitch on what they think I should do.
Sorry about that.
Nope, you're fine. Go ahead, Mr. Christensen.
Your Honor, at the same time, I was filing an amended statement on November the 18th of 2024. He served a state's attorney with a very official-looking document entitled Form COL, Violation Warning, Denial of Rights Under Color of Law, Violation Warning 18 U.S.C. Section 242, 18 U.S.C. Section 245, 42 U.S.C. 1983. And it was addressed to myself, Paul Christensen, Stevens County, 215 South Oak Street, and indicated in bold letters, federal law provides that it is a crime to violate the rights of a citizen under color of law. You can be arrested for this crime, and you can also be held personally liable for civil damages. He also went on to advise me to cease and desist and to seek professional legal counsel. So after the defendant's motion to dismiss was denied by this court on November 25th of 2024, he requested and received a continuance for the trial the same day. And then he filed some additional documents. On December the 4th, he filed something called the Notice and Demand for Abatement that included additional allegations against the state's officers, official misconduct, harassment, robbery, criminal mischief, all of these from the same incident where he was arrested for having fake license plates, obstructing, failure to transfer title. He filed another motion to dismiss and a memo supporting that, where he made a number of different bullet points: unlawful stop and interrogation, violation of the Fourth Amendment, threat of arrest without probable cause, abuse of authority, fabrication of charges, violation of his right to privacy, causing emotional distress, and alleged the officers had no legitimate basis for any of their actions. On December 13th, he filed another motion to dismiss with similar allegations of crimes, civil wrongs allegedly committed by sheriff's deputies and the state's attorney. So all of this to say, Judge, that this puts the state in an interesting position in terms of coming up with a response to all of these kind of vague allegations, very inflammatory allegations in this case. So basically what we do is look to the law as it applies here, starting with the court rule 8.3, provides three bases for dismissing a case pre-trial. Section A is on motion of the prosecution. Obviously, if that's not pending here, on motion of the court in the furtherance of justice after notice and hearing may dismiss any criminal prosecution due to arbitrary action or governmental misconduct when there has been prejudice to the rights of the accused, which materially affect the accused's right to a fair trial. The court shall set forth its reasons in a written order. I heard a litany of complaints from the defendant about police officers, myself. There's even some things about judges in there. None of that has to do with his right to a fair trial, how it's been impacted. He still has a right to a fair trial. We have a trial set next month. None of those trial rights have been impacted in any way that he's put forth today. And finally, on the motion of the defendant for pretrial dismissal, the defendant may, prior to trial, move to dismiss a criminal charge due to insufficient evidence establishing a prima facie case for the crime charged. In this case, Judge, there is a prima facie case shown by Detective Feldner's affidavit, as well as the attached photographs that actually show the false fictitious license plates mounted on the defendant's vehicles. The defendant claimed that there was no intent to defraud as part of this forgery. However, I submit to you that that is incorrect. Simply looking at the photographs here, those license plates look very official. They have a number. It reads 0777 YAH, title 18242. These fictitious license plates were mounted on the front and rear bumper of the car that was on a trailer being pulled behind the truck. The flatbed trailer had no plate, fictitious or otherwise, and it was mounted in the back of his truck. The forgery statute finds someone guilty of forgery if, with intent to defraud, they falsely make, complete, or alter a written instrument, or possess, utter, offer, dispose of, or puts off as true a written instrument which he or she knows to be forged. That's RCW 9A 60.020. That's the felony the defendant's charged with. The written instrument is also defined in the code, RCWs, as any paper, document, or other instrument containing written or printed matter or its equivalent. In this case, we have printed matters, the license plate number, as well as some number purporting to be a legal code, Title 18242. This case is similar to other cases that have been in front of this court recently for forgery of a trip permit. Trip permit is basically the same thing as a license plate. It allows a person to drive on the state's vehicles. And I referenced a couple of recent cases to show the court, again, discussing Mr. Ochoa Ibarra's allegation of prosecutorial misconduct or malicious prosecution, or somehow making this up or making this an extraordinary case. This kind of prosecution happens all the time. The proceeds from the fees that people pay to register their vehicles, all people, whether they agree with the law or not, have specific purposes in the statutes that have been designated by the legislature to receive those fees. They go towards State Patrol Highway account, Puget Sound Ferry operations, and Motor Vehicle Fund. And that's RCW 46.98.030. By affixing a false, fictitious license plate to his vehicles, the defendant tells police officers and everybody else that he has paid his registration fees, while in fact defrauding the state out of that revenue that everybody else is required to contribute for in order to maintain safe roads upon which everyone can travel. So when Detective Feldner saw the defendant pull into the gas station with no plate on his vehicle, he approached the defendant and requested his driver's license. The defendant went into a lengthy argument with Detective Feldner and eventually other deputies that there was no crime. He didn't have to show Detective Feldner anything. He basically refused to comply with basic requests for information. Hey, you see your driver's license. Therefore delaying Detective Feldner's investigation for a substantial period of time. And the fact that Mr. Ochoa Ibarra does not want to show his driver's license, well, I guess he can take that view. However, the law is otherwise. RCW 46.20.017 says that anyone operating a motor vehicle is required to have his license in his immediate possession at all times and display it upon the demand of a police officer. Detective Feldner took these plates seriously. This wasn't some kind of a fake vanity plate. It looked real. He tried to run the plate. He he tried to look for, he found no record on the plate. He tried to look for a vehicle identification number. And he eventually was able to run one. It came back to a vehicle, a Chevy Silverado, that was supposed to have the plate of C49226U that was expired. The registered owner of that vehicle was Juan Penaloza Loya. The vehicle was marked as sold, but the title had not been transferred, as is again required under state law. So that's why Detective Feldner impounded the vehicle so that he could determine ownership of it, as there was no proof of it otherwise. So the state has made out a prima facie case for the forgery charge, for the obstructing, and for the failure to transfer title. So there is simply, Judge, no basis to dismiss this case pre-trial. And we're not going to be bowed by threats or anything else the defendant puts forward. I would just ask the court to deny the motion again. This is now the second motion to dismiss that's been filed on this case.
All right, thank you, Mr. Christensen. Mr. Ibarrocha, any response here?
Yeah, so
Sorry.
he was going over a lot of the stuff that I ended up putting forward, just like he was trying to make it seem like what I was putting forward was evil in any way when it wasn't. It was actually biblical, like about corrupt judges and stuff like that. I'm not saying that you're corrupt or anything, just stating that, you know, whoever does certain things is corrupt, you know, that would violate, you know, the Constitution or anything like that. He also stated the COL form that I gave them. It's actually a federal form. You guys can look it up online. This is something that is given to someone that does violate someone's rights. So it's a form that anybody can get online. So also his need to respond to all of this when I've just stated all the facts right here of how there was no ill will or intent, and how I do have the right to not pay certain fees because it goes against my religious beliefs, and also stating that just like how I put on here as well. There's just go over real quick with the second am jurisprudence. And it also goes against life, liberty, and pursuit of happiness. I can't, you know, for them to try to hold me back from practicing the right and trying to make it a crime to practice the right is unconstitutional. Just like I said in 51M jurisprudence, second edition, it says a state may not impose a charge for the enjoyment of a right granted by the United States Constitution. If this is granted by the United States Constitution, you can't be trying to impose all these fees that the state is trying to impose and try to say that, oh, well, this goes to the roads and stuff. But we also know that gas tax goes to the roads. We know that all these things that have to do with a driver or traffic, it's all under commerce. Just like when someone traffics goods or people for a fee, that's trafficking. So when you get a traffic violation, this trafficking is for trafficking that has to do with, just like if we go back in history and we actually see why this whole licensing stuff came about, was to charge those people that were going to be driving on the roads in the commercial capacity, making the roads their form of revenue, then they were going to get charged these extra taxes, and that's why it actually came about, you know. But the ignorance of the law is no excuse, and just because people don't look into the law, they don't know these things, but it's all in there stating that these things are definitely, you know, fall under the commercial clause, which is the only way that the state can try to charge for these things. But if the people actually know their rights, then they actually do have the right to travel and put whatever plate they want on their car. My plate was definitely not even close to showing any other state plate, as you guys can see, and these other let me see, these exhibits that I ended up putting. So Exhibit A includes a picture of my private plate showing that the plate does not mimic a Washington state plate. It has in lowercase letters state of Washington. Every plate that I've seen has capital letters state of, you know, it doesn't even say state of Washington, it just says Washington. State and with this was just stating where I live. It does not display Washington capital letters. The nor does it contain a placement for tabs like a Washington plate. Additionally, under 077 Yall, it has the wording Title 18242, which is, a federal code, stating that it's deprivation of rights under color of law. There is no plates that even look close to similar as my plate. So I don't know what he's talking about. Also, yeah, also the whole prejudice thing, it's straight up stated that the first thing that he ended up labeling me was a constitutionalist and a sovereign citizen. So that just shows that there was prejudice. Like, so I don't know what the state is trying to say with this, by trying to bring up other things that I ended up putting in my other motions. I was actually perfecting my motion, trying to figure out in what order to put all these arguments, especially going through this stressful environment of and and irreparable harm that they caused. So there was a state of mind that I was not all fully there at the time because of the irreparable harm they caused to me and my family, which I will be filing an injunction for that. Also, um, they stated just because I have a plate in front in the on my back and in the front of my car, there's a whole bunch of um, all these other people that go take their cars to car shows and have their own their own plate, their own private plate. Also, you go to like a dealer and they all have private plates doesn't mean that they're fictitious in any way. Um, just because I decided to put one on my truck and it wasn't even to defraud the state at all whatsoever, which it still hasn't been um, it hasn't even been proven. All he keeps on claiming is that I intended to defraud the state, but he has no proof at all. Like there is no facts that is proving this. When I just stated that I have a lawful right under the Constitution and under all these Supreme Court cases that overrule any any other state court. So and also for them to try to take my truck just to determine ownership when they looked it up and found who was the recent owner, and I showed them an affidavit of consumer goods stating even having the name of my wife's dad, Juan Loyola, on there. They still tried to impound my when I gave them proof that this was an affidavit showing that it was an agreement between me and him that he was gifting me all these things to me. So I had proof of all of this, and yet they still wanted to try to take my stuff to prove ownership when they basically looked it up online and saw who was the owner before it, and I had the paper with the affidavit showing his signature and stating that he was gifting me these things. Uh, and also he keeps on stating RCWs that straight up violate the Fourth Amendment. For me to be parked at a gas station and for someone to come up to me and start asking me for ID when I'm outside of my vehicle just talking on the phone and for to demand ID violates the Fourth Amendment, and not just the Fourth Amendment but Article 1, Section 7 of the Washington State Constitution. So the Constitution trumps RCW. So I don't know why he keeps on bringing up RCWs. It straight up shows right here that they violated my Fourth Amendment, but yeah, he doesn't want to bring up the Fourth Amendment. So he's actually going against the Constitution when he actually takes a note to uphold it. And like I stated, I wasn't trying to get out of paying anything towards the state. I'm just practicing the right. You can't convert a right into a crime, or the practice of the right into a crime. The Constitution, is there to protect us and from any violation of anybody that tries to usurp authority over us that goes against the Constitution. And obviously, there's a lot of things here that go against the Constitution. He keeps on stating that my plate's fault and fictitious when he still hasn't even proven that. Um, I just straight up shown him my intent behind it all, and with with law, like backing it up with law and case law from Supreme Court cases, and he still keeps on stating that it's false and fictitious. And you can obviously see that it mimics not even close to a Washington State plate. And he's still not even speaking about the whole unlawful arrest. So how can you even continue with knowing that there was an unlawful arrest without probable cause? And also, um, there was also the being prejudiced. Like I can't have a fair trial with these two cops calling me a constitutionalist. Like the Fellner, once I went into the jail, he was saying, "Oh, we just got another constitutionalist." When they take an oath to uphold these things. So that's straight up treason. Like you can't go against the Constitution and saying, "Oh, like saying it like in a bad way." When they actually have to uphold this, they take an oath. I have their oath of office, and it straight up says on there that they are there to uphold the Constitution, but yet they're putting it down like if it's something bad, you know. So yeah, well, just even the whole Fifth Amendment of the U.S. Constitution, along with Article 1, Section 3 and 22 of the Washington State Constitution, ensures that criminal law are clear and provide fair notice of prohibited conduct by attempting to criminalize conduct not addressed by law. The state deprives the defendant of due process. And there was definitely prosecutorial misconduct, and that it should be dismissed because of the charges that were there was prosecutorial actions amount to arbitrary governmental misconduct that prejudice the defendant's rights to a fair trial, attempt to fabricate felony offense. We can see in the videos that they were not even cut in any way. That it's straight up the video, and many people ended up seeing that there was definitely a misconduct. It's not just from my opinion, but also the not just from other people, but also from the law itself. The Constitution, shows this stuff as well. That they've definitely violated the Constitution. So we can't dismiss that at all just by trying to go off a mere statute. Um, just as we stated that the Constitution is above statute, and if someone tries to arrest you for let's see for yeah, for obstruction, yeah, like trying to say, oh well, that I had to demand identification when I was just there standing outside my truck talking on the phone. For someone to demand ID when it's obvious that it goes against the Fourth Amendment and Article 1, Section 7 of the Washington State Constitution, and for him to continue to bring up RCWs, trying to say, oh, that we have to, knowing that the Constitution protects that right, especially because there was no probable cause. If I were to commit a crime and cause harm or injury to another person, I would have definitely gave up my ID. Like there is no doubt about that. I'm not out there to cause any harm to anybody. I just want to show love to everybody. Like it's a command from God that we are to show love to everybody. That's why I don't get all like you guys seen me that I don't get all crazy in court and start like yelling or getting demanding with anything. All I'm doing is trying to uphold the Constitution and the rights that we have as a people. And just like I said, I follow the Bible, and the Ten Commandments is a moral law. Our founding fathers actually put the Constitution together with that in mind. because that's where all morals come from, that you shall not kill, you shall not steal, you should not covet, your neighbor's goods. So, and just the fact that I have that First Amendment as well that protects my right to all of this as well, with me being able to go out and preach the gospel wherever I need to without you know being restrained or held back by a tax or a fee that is unconstitutional. Because if it's upheld as a right, and you can't go against it. And I just show that it is a right, just according to 51 jurisprudence, second edition. That states that a state may not impose a charge for the enjoyment of a right granted by the United States Constitution. And just like the Ninth Amendment says, that just because it doesn't specifically state it in the Constitution doesn't mean that we don't have those rights. But according to the 10th Amendment, to those state officials and the ones that are limited, of their powers, it shows in the 10th Amendment that if it's not specifically stated in the 10th Amendment, then they have no power outside of that. That's it, Your Honor.
All right, hang on. Before I go on, Mr. Grady, do I need to sign those to get Mr. Carmen out of here?
I have one other matter, so.
Oh, okay. All right. Um, you've got a lot going on here. And I remember when I did your arraignment, I tried to talk you out of representing yourself because a lot of the issues that you've raised in this case, a lot of the arguments that you're making are arguments that are appropriately made at a trial. There's different legal theories that you've now just presented in your oral argument that weren't necessarily pled out. And like Mr. Christensen indicated, he struggled to understand what theory you were coming in under to dismiss this case. You have raised, when I listened to your argument this afternoon, you've raised challenges that the law requiring that vehicles in Washington carry license plates is unconstitutional as it's applied to you, but there's a whole analytical framework that you have to engage in. You cite to legal authority in your memorandum that's not binding, whether it's in state or federal court. There's a lot of things that you have also in your argument that you identify as what you believe are legitimate issues with things that you disagree with that happen on the state in question. But the fact that you disagree with them does not rise to the level that supports a dismissal. Another issue, a lot of the things that you talk about with respect to the credibility of the officers, a lot of the issues that you talk about with what's on that body cam, the interactions with law enforcement has, the things, those are fantastic arguments for a trial situation. But the framework that you've come under is very limited. And again, we talked about court rules at your arraignment, and Mr. Christensen cites to the court rule, and that's 8.3. And he talks about the three ways that the court can dismiss. The first one is that there's a motion by the state. And it's clear here that the state is not making any sort of motion to dismiss in this case. The second issue is that it's on motion of the court. And that the court, in the furtherance of justice after notice and hearing, may dismiss any criminal prosecution due to arbitrary action or governmental misconduct. where your ability to have a fair trial has been accused. And I can handle a lot of these issues that you've raised, the things that Sergeant Swim made. If you find them offensive, if you think that some of the things that were said inappropriately, we can talk about that in front of, before we get to a jury, so that the jury doesn't hear on that. So we do that all the time. We don't let prosecutors and law enforcement refer to individuals as defendants. We use proper names. We don't talk about victims of crimes, because when a case is a trial, they're alleged victims. So a lot of this I can handle. So when I look at the analytical framework, I conclude that you're coming under 8.3C, which is the other option, that there's not sufficient evidence in this situation to support these charges, which is where Mr. Christensen began his analytical framework.
Also, I'm actually coming under B, where it says that there has been prejudice.
Right, but I'll get to that, but that's, again, you're misreading the rule. The court on its motion. So I'm the one that makes the decision, and I mean, there's other ways, there's other procedures that you're not following, because, like, again, your constitutional challenges, that's a whole different analytical framework. A lot of the relief that you're asking for is not available to you in a criminal case.
Are you not going by the Constitution?
No, I'm going by the Constitution, but the thing is with any time we have a hearing, you give us notice on what you're doing. We prepare in the analytical framework. So if you want to bring a unconstitutional challenge to the licensing statute as applied to you, there's an entire body of law that I have to go through. I didn't know that that was what you were going to argue today. So I prepared for an 8.3 dismissal. That's what I'm prepared to talk about today.
But it's all in my motion.
It's not. That's the issue, is you just cite to these things. There's an entire analytical framework as unconstitutionally applied that you not go through. There's an entire body of law in Washington, everything. There's a procedure that you've skipped over that. And that's the issue. So walking in, literally, Mr. Christensen, if I understand correctly, 8.3 is why we thought you were here. Because again, there's no citations to court rules. There's a mix of binding and unbinding authority. There's just this, and I asked you to clean it up so I could understand. So here, I'm going to start with the no valid legal predicate for threat of arrest under 1031-100. I'll observe first off that at the time the threat was made, there was no arrest. There was just the threat of arrest. And again, I don't see where there's any legal authority that you've cited to that indicates that a threat of arrest is somehow justification to the next step, which is dismissal in the situation. 1031-100 does provide that you can be arrested without a warrant if the offense is a misdemeanor and it's being conducted in the officer's presence. There's facts in this police report. Maybe Deputy Feldner, or Detective Feldner did not articulate that, but at the point in time when the threat to arrest was made, law enforcement had sufficient information the title had not been properly transferred within 45 days. So had they made the decision to arrest, which they did not, it would have been a valid arrest under 1031-100.
I go against that because it says that it specifically states that there has to be an injured party, and also that there also has to be I have it right here. You know, and there actually wasn't any of these things present at the time. So it says that any police officer has any probable cause to believe that a person has committed or is committing a misdemeanor or gross misdemeanor involving physical, so it has to involve physical harm or threat of harm to any person or property. There was no felony stated at that time either. The rest goes into domestic violence, extreme risk protection order. It doesn't fall under any of these. Household. All
right, and we can do this all afternoon because I know you're going to disagree with a lot of this, but
I have the RCW.
And I'm looking at it too, and it says a police officer may arrest a person without a warrant for committing a misdemeanor or gross misdemeanor only when the offense is committed in the presence of the officer. Failure to transfer title within 45 days is a misdemeanor. There was evidence that it was being committed in the officer's presence.
Well, that goes against the Constitution, though.
Again, we're back to where I was earlier. You have not briefed or analyzed unconstitutionally as applied. That's the struggle that I have.
You're saying because I haven't said that this is unconstitutional, that's why it doesn't apply?
No, I'm saying that that's not the issue I'm addressing today, because in your briefing, and we talked about this at your last hearing, I told you, clean this up so I understand what you're trying to argue here. Tell me what court rules you're coming under. You didn't. You just filed the same thing over again. So I'm analyzing this from an 8.3. I'm not making any judgments on constitutionality or unconstitutionality because they have not been properly briefed. So I can't even get there today.
The Constitution should be above everything, though. That's the first thing you should bring, like you should back up.
I appreciate that, but you have not filed a notice to dismiss for an unconstitutional challenge as applied to you. There's an entitled procedure. So I'm going to move on. I know you're not going to agree with a lot of this. This is all appealable. So the fabrication of a forgery charge out of non-existent authority. I know that you, again, we're not talking about the constitutionality of this because at this point in time, no proper challenge to the constitutionality has been made. So it states that forgery, you're guilty of forgery if with intent to injure, defraud, you falsely make, complete, or alter a written instrument. RCW 9A60-0107 defines a written instrument as any paper document or other instrument containing written or printed material or its equivalent, or an access device, which is banking information that doesn't apply. So there is no case law on point that talks about license plates. But there are two decisions. The first is State versus Hyslip, which is 77 Washington 2nd 838. And it states that the intent to defraud is a crucial element that must be proven beyond mere possession of the fake item. So here, that's a jury question. The jury's going to have to decide if you were intending to defraud. That's not something that I have here because, as Mr. Christensen indicates, based on the fact that folks that license their plates as they're currently required by Washington state law, they have to pay into a fund that goes to maintain the funds. They have to have valid license insurance in order to get some of these issues. So that
I showed my intent, though. So how could he go against my intent when he's just making stuff?
it is a question of fact for the jury to decide. You can make your pitch to the jury, law enforcement can make their pitch. The jury will ultimately decide if they believe that what you were doing was an intent to defraud the state. Now, there's also a case of State versus Esquivel that has stated on point that the fabrication and falsification of government documents in response to a police request for identification can constitute a forgery. That's what law and license plates are used to identify vehicles. So there is analogous case law that does support a conclusion that having a fake license plate in this situation would constitute a forgery. Now, the issue of prosecutorial misconduct and the escalation of felonies. So again, I've just indicated that I believe that there is case law. I know that you don't agree with this charging decision. I can tell you that a lot of the people that come into this courtroom don't believe that the facts of the things that they've done warrant the type of response from the state that they're getting. But the bottom line is case law and the facts and the statutory definitions do establish that you or support a conclusion that a jury could reach that this was a forged license plate. Again, the prejudicial labeling by Sergeant Swim, that is not something that you've cited to any authority that leads to a dismissal. That is something that is appropriately addressed in a pretrial motion that can be precluded so that the jury doesn't hear about any of that. A violation of due process and fair notice. Again, I've touched on that. That was another collateral attack to the forgery charge. Here, under 8.3 and NAPSTAD, which is the applicable case law here, is I have to look at the light in a most favorable way for the non-moving party, which is the state. Not to beat a dead horse, but the forgery charge is supported by the law and the facts in this case. The obstructing, again, I know you don't agree with it. There has not been a proper constitutional challenge as applied to you of the requirement to show your driver's license in this juncture. So therefore that stands as valid law. So there we have the obstructing, which goes beyond that. It wasn't just a failure to provide the license plate. It was that entire interaction that extended this. And then finally, the failure to transfer title is likewise submitted based on what they've done here. So I know that you don't agree with a lot of this, and I talked to you at the time of your arraignment. There are things that you're going to have to do as part of this case, because I know you're probably frustrated that some of the arguments that they're not being presented. I would encourage you to rethink the idea of an attorney. There are procedures. I've presided over trials. If this ends up going to trial, it's gonna be challenging for you. So it's not, and I respect where you're coming from. I respect the incredible impact that this has happened on your family. I think you and your wife should write a book on parenting, because I've never seen children so well behaved in this courtroom before. But the bottom line is I'm not diminishing the trauma of everything that happened to your family. I get where you're coming from as a father. If I was in the same situation, I'd have that same emotional reaction. The problem that you are running into is that I have a set of parameters that I have to look at of all these issues. And that's, we've had these interactions, and I can kind of see the struggle there, is that you've got things you want to say, you've got arguments that you want to put forth, but there's a procedure that I have to require you to follow, which I require every other person in this courtroom to do. So for today's purposes, I analyze this from a CR 8.3 motion. I don't find any misconduct like Mr. Christensen indicated. This has been supported by probable cause. I've cited to case law that is analogous to this situation. There have been multiple other cases where individuals have been prosecuted on trip permits. And in my mind, I don't see much of a difference between a trip permit and a personal plate in this type of situation. It's something that is properly issued by the state that was changed. So for those reasons, I'm going to dismiss these motions. I'm not going to dismiss, I'm going to deny the motions that are before me. So that leaves us with the status conference as well as the omnibus order. Are you in a position to look through the omnibus order and have that completed today, or do you?
I would have to take a look at it.
Okay, and then where does that leave us as far as our trial date that's currently set for February 19th? Are we anticipating going to trial at that point?
I have to think about it. Because there's just been a lot of irreparable harm here, even coming to court. So I'm gonna have to file a injunction for all this.
What's that?
I'm gonna file an injunction for all this for irreparable harm. Because it's just like, there's been a lot of irreparable harm for me and my family, even just coming to court.
You turn off okay. And again, you're citing the civil rules that don't apply in criminal cases. You could again, I'd strongly encourage you to rethink your position on an attorney. Do you want to look at the omnibus border and then let me know what you're wanting to do as far as your trial date is concerned? Okay, all right. So Mr. Christensen, can we give Mr. Ochoa Ibarra that to look over, please?
Yes, sir.
All right, if you want to sit back, there's a couple more cases that I need to work through.
Thank you, Your Honor. Thank you for being alive.
I appreciate you also. Thank you, sir. Mr. Carmen?
Yes, Your Honor. If you want to deal with the one I have orders on, or just.
All right, so y'all tell me now. Okay, so what do y'all think about this situation so far? It's very bad because the judge is not honoring the oath. He's saying that Luis needs to do some kind of procedure. It needs to be an attorney at law. It needs to get an attorney to help him with this when the judge can just do it. He be acting like he can't just dismiss this bad boy right there and then, or move the prosecutor to have this dismissed. Why would they do that? That's what's got me confused right now. I'm trying to figure out, why would you do that? Like, why, if you're seeing what's happening in relation to the aspects of just justice in and of itself, why would that not be something that you want to do? I don't understand that. I'm lost for words right now in relation to that. Like, why is you just not moving forward, knowing what's happening, looking at the situation, saying, you know what, I don't see that there's probable cause. Like, that's what you should be doing. You trying to take it onto the aspect of saying, oh, well, you don't have this before me, and now you have to invoke this whole other body of law, and, now we need. Okay, well, guess what? We're going to figure that out then. And I guess we'll have to do another notice hearing in relation to the constitutional aspect, since you don't want to make it so easy. Or Luis, just as he said, might file an injunction. I don't know which way they want to go. I heard the judge say, can we turn that off for a second, as soon as Luis said something about an injunction. I heard it. I know what I heard. See, and then Christensen don't even make a proposed order for the judge to deny. Luis has already have a proposed order of being granted. He needs to go back in there and just say, Your Honor, before we leave here today, and go into it again. I would, me myself. I'd go into the aspect, and then I'd be like, and if you're not going to rule in favor of me today like you have, I'm just going to have to, put in this motion for disqualification. And just put in the motion for disqualification, bro. If he's not moving forward in relation to the bias, you've clearly invoked everything that you need to invoke. You don't have to be a law scholar to come through and have the judge do the right thing. That's like, don't be sitting here trying to apply all these rules. I've already told you I'm here under special appearance, bro. I'm not sitting here like schooled in law. Don't sit here and try and apply all that to me. But they just don't want to. He's not trying to respect it, and that's unfortunate. I was thinking because, and it's because homeboy never refuted anything. It's like he's saying, "Well, I do find it as a basis because it's a misdemeanor," and then Luis reading right from the statute that where it says that it has to have some kind of harm. And you talking about it's, any misdemeanor. Bro, that's in relation to me doing commercial aspects. I've already showed you a driver is one, operator is one, doing commercial. Like, y'all ain't even following the statutes. It's like you sitting here saying I don't agree with you, but you're not even reading the statutes in line on how they are applied. Like, I don't get what you're talking about. I've already invoked the rule of lenity here. You just said on the record at the very end that you was denied it on the basis of opinions in relation to fake trip permits as a document. Bro, it's like you going outside of the rule of lenity. Like that's been invoked. The rule of lenity has been invoked. How you gonna go outside of that? It has to be very clear. Not only that, I've invoked the whole rule act. So it's like you're saying all of these things are things that I'm supposed to argue with the jury. No, that is not the case. The jury's not going to know nothing about this stuff that we arguing. What's to be argued is how it's being applied right now. You're not looking at it for what it is. It's fake trip permits. I don't have a fake trip permit. That's like if I had it says with intent to defraud, and you sitting here being like, oh, well, the jury that's a jury question. No, that's a question now because I have irreparable harm by continuing to come here. Like, what don't you get about that? So it's like we're going to have to hit him with a stay and injunctive relief. And I mean, I don't know why he ain't hit him with the disqualification yet. I thought he had that bad boy ready. I don't know why he's saying like, oh man, the judge is over here sitting here telling him, you need to do this. You need to get an attorney and scaring him. He's scaring him now. Like he's not going to be on his side to defend him. What do you mean, bro? Bro, he's invoked the rule of lenity, which is supposed to be ruled in favor of the defendant. What don't you get about that? You over here utilizing some other shit talking about, so he's like, bro, the judge is biased. If they go, I would be just right back arguing. I'd be kind of like Lane is at this point. See, Luis kind of steps back and lets them talk, but I would be just like, I'd be standing my ground more. I'd be a little bit more with what I'm doing because it's not like you're going to find me in contempt for standing up and invoking what I know to invoke. Like he hit hard on his whole explanation. Everybody knows what he's got to say and it's true. All the way. He's let it down. And this dude's like, well, you're going over here and you're going over there. And it's like, bro, I'm speaking the facts. These are enough facts to let you know I don't need to be in line with this little bitty ass statute I understand you work for the state, and I understand that you go after people who are supposed to have corpus delicti and a verified complainant. But I really do think, that, I don't know, man. Luis said he's going to file an injunction. And apparently they're supposed to talk some more here, so I'm going to let them get to talking, and we're going to see what's supposed to be happening here. I need to take a restroom break, man.
Gonna need to look at that too.
Yeah, he is going to need to look at that too.
He's gonna need to look at it. Yeah.
It's a travesty. I'm letting them know. I'm letting them know in their own chat. It's a travesty upon our people, man.
Today is omnibus. Yeah, if you want to come back up to the microphone.
Travesty, bro. Such a travesty what they're doing to my boy. Ridiculous. He needs to hit him with a disqualification.
So everything that has an X on it would pretty much be something that I would have to do then.
I'm trying to find an example of one we've entered just to make sure that I know.
I know, Doug. He was talking about he has to invoke something else, but homies already invoked rule lenity. They're not staying in line with that. He did good, though. He did amazing.
Where is it?
I just can't believe judge ain't already, like, dismissing it. He's supposed to rule in favor.
Yeah,
In the
so
rule of
basically, if there's a box marked, if I remember correctly, there's the section that addresses what the state has to provide you, and then also what you're obligated to provide the state. So if it's been checked, those have to be exchanged.
Okay.
So for example, like on this one, this is from a different case. So the prosecutor has to provide you all of the evidence that they have for the names of witnesses, and their statements. And then if you want to make any request to inspect evidence, they can do that. We can have a 3-5 hearing, which is to determine if your statements were admissible. And then there's a lot of this won't apply, like if there's an informant involved, or anything along those lines.
So this is my copy, the second
That's the original.
original.
Yes. So do you want to sign off on that?
Well, I don't really like giving my signature.
That's fine. Well, okay, so I can do what we've done in the past, which just indicates that you were here. And I'll just run through what they're asking, your obligations are, just to make sure that we don't have any issues here. And, Mr. Christensen,
I
this is
disqualify that dude.
motions made by the defendant to require state compliance. I'm assuming there's no informant here.
Correct.
Okay, so that first one is not applicable. The second one is to disclose evidence in the state's possession favorable to the defendant on the issue of guilt. So this one's already been checked. So whatever police reports, other information they have, they will continue to do. Provide that, to disclose whether or not they will rely on any prior bad acts. So basically what that means, if you've ever had similar charges, whether they're going to try to introduce that. If they are going to try to do that, they have to provide you notice. We'll have a hearing on that issue. Mr. Christensen, are there any experts that you're anticipating calling in this case?
No, Your Honor.
Okay, so I'll indicate that that is not applicable. If there's are any reports or anything else like that, test, physical examination, I don't think it applies, but if it does, then they're going to have to provide that. If there was any scientific experiments done, again, they'd have to provide you with that. You then have the ability to look at any evidence. So if there's evidence in the evidence facility that you want to look at, it'll be a little bit more involved because you're choosing to represent yourself, which is fine, but it is your absolute right to look at the evidence that they have that they are intending on presenting. And then if they have any prior convictions.
See, I just don't know why he's not going ahead with the motion of disqualification. I don't know why. If not, I don't know why he's not bringing it up.
There's a court rule that specifically indicates what you have to disclose to them, the substance and all of that. So if you look in the criminal court rules, any other questions about what's in this?
No.
Okay.
Yeah, I was gonna get a copy, right?
Yep. And then that other document is the denial of the motion to dismiss. So again, I can just indicate that you were here and that you did not want to sign that. Can we have Mr. Christensen sign that? And then did you decide what you want to do about your February 19th trial date?
Um, yeah, I would have to think about it, or you know, I need some time to think about this stuff.
How much time do you need to think about? Because the 19th is coming up on us pretty quickly. If we came back, probably have to be a week. Would that work?
Yeah.
And Mr. Christensen, is that agreeable to the state, just 1 week?
It is, Your Honor.
Okay.
Dang, I'm gonna have to show up. I'm gonna have to go out to Stevens County.
And if it's easier for your family to call in, I mean, it's, again, I'm not saying one way or the other. It's just an option for you guys. If it's easier to call in at that point, instead of having everybody come in, we're more than happy to have you. But you're also able to do that if that's, like I said, just more convenient for you.
Thank you.
Okay, so we'll get you copies of the other documents. Mr. Christensen, anything further in this matter this afternoon?
Thank further, Your Honor.
Then Mr. Ochoa, Ibarra, anything further that we can do this afternoon?
Well, I really want to thank you, like, you know, like, go against like the Constitution. I really hold that pretty high.
Like recuse what?
Because of the Constitution that I.
Okay, I need you near a microphone.
It's just because of like,
Okay, wait, back up. Who or what are you wanting to recuse?
the judge, just for, pretty much going against the Constitution
Myself or the other judge?
yourself.
So at this point in time, I've made multiple discretionary rulings in this case. So the only mechanism, again, there's a court rule and a procedure that you have to follow. So again, I got to refer you back to the court rules. Again, I'd really encourage you to talk to an attorney that practices in Washington that understands all of this. All right, so I've signed off on everything. With that, we are adjourned, and I'll see you next week.
All right. Where's the doctor?
These scrubs. Y'all want me to call him? See what he says? I bet you he wants to talk to his fam, but I want to get to him before he starts to travel. Let me see if I can. These scrubs, bro. They're such scrubs, bro. They're such scrubs, bro. We'll see what way he goes next. What way he wants to go. How do I get myself up off of if I just do that? Yeah, I can do that. Okay. Man, this scrub. Why ain't you disqualify that nigga, man? Yeah, no, he's talking about to go to a process. Yeah, you should have just hit him right there with it. I'd have been like, yo, man, I'm just gonna have to go ahead and file for a recusal right now. You didn't have the recusal ready? Oh, all right, let me do it like this. Let me do hold on. I got y'all. My bad. All right, can you hear me now? Yo, yo. Can you hear me now? Okay. So, why didn't you just file for the motion to disqualify him right then and there? Man, he just keeps. It's so crazy. He keep suggesting you just to get an attorney instead of just doing the right thing in the first place. But it's crazy too because when you hit him with when you started talking to him about the injunction, he said quietly, he said, "Can you stop this?" Just like that, bro. I got it. I got it. I heard it. When you mentioned when you started mentioning the injunction, he was like, can you stop this?" And then he started to act crazy about it, bro. Then he just went right back into it. I heard it, bro. I heard it, bro. He goes, I'll find it. Wait, wait, wait. Your audio's not coming through. What the heck, bro? No, with you talking, no, I'm talking about the audio for the. Wait a second. I can't. Oh my gosh, bro. Where's your audio? Can you speak? It's, yeah, I can, but I don't think my people. Yeah, I can, but I don't think my people can. Hold on. I think I gotta take it off Bluetooth. Um. Okay, now talk. Yo, yo. Yeah, I don't know what's going on. It's not working right. Yeah, it's
Do you have
weird.
your like your earphones on or something?
I
Or
took
the
them
phone?
off. I took them off.
Oh.
And let me see if I even do. Yeah, but you hit him hard, bro. I can't believe Homeboy wasn't on your. I can't believe Homeboy didn't do right, bro. I would have swore
Yeah,
that
no,
judge would have done right, bro. That's horrible. They look so bad.
that's what's a trip, man. Because they were straight up violating the Constitution, like, and that they were trying to bring up things that like saying that, oh well, that's not what we were here for.
Yeah, that's wild, bro. So what are you gonna do now? What do you think you're gonna do next?
Well, you think I should just do that one that what is it,
Injunction?
the injunction?
I mean, we can go about it, bro. You go up. If you didn't want to disqualify him, I would have filed for a disqualification right then and there on him. But if you didn't want to do it like that, I mean,
Yeah,
I would
yeah,
have
because I
though.
wanted to I just wanted to kind of edit the injunction a little bit more and add more to like what you had in the video, because you know you were backing it up with certain other things that were on there, like even scripture as well, and so like because pretty much what this injunction that you gave me, all it is just a repeat of my motion.
Well, yeah, and they're just repeat. It's crazy because when you look at it, like the judge is sitting there acting just crazy with you, anyways. Like everything wasn't like I don't know. I feel like I would have objected when the judge was talking a little more. Cause he's even said in
Yeah,
there at one point, he was like, at the very end, he was like, yeah, and I find it in rule or in something in alignment with blase 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 for, oh, what was it, bro? It was for fake trip permits. I heard it. It's right there on the
yeah,
record.
I know.
And I'm just
Yeah,
like,
for
I'd have been
fake
like,
trip permits.
objection. But see, you're trying to again relate fake permits to my own private property. Like it
Yeah.
don't correlate. You again, nobody here is bringing in your. And he may be arguing all
Well,
that,
that's
but
what I
it's like,
brought. Well, that's what I brought up with what's his name with Christensen, because he brought up the whole fake trip permit, and I corrected it on there as well for that it has nothing to do with the fake trip permit. Like I just showed him by law that I have the right to do this.
well, I mean, you put a lot on the record there. I think what's crazy is that they're trying to do it by jury trial. You can see that this guy's not in. He's not ruling like he's supposed to. Didn't you invoke the rule of lenity?
Yeah, it's on the motion.
And he just bypassed it.
Yeah, yeah, it is
Well,
bringing
why didn't
it
you
is
bring
bringing
that up?
everything up.
Why didn't you bring that one up too?
Well, just because it's already in the motion, so it would be on record. And I was trying to hit more of the points on the arrest without a warrant and stuff, and
Well,
he's like,
Ralph
oh,
says
just because they
Ralph says move the case to a federal court. Coyote injunctions.
coyote injunction.
Yeah.
What? Like, how would I do that? I would just pretty much file some paperwork moving it to that.
Well, the injunction would and move it up to at least the next highest level.
The injunction would.
Yeah. Yeah.
Yeah,
Yeah.
yeah, because they said that they want me to come in next week.
Well, man, what do you want to do? What do you want to do? Because
Well, that's what I'm saying.
you
That
can't
that
file no injunction with them. And if they want you to come in next week, I don't even know what you going there. What you going there next week? What you going there
well,
for?
they just pretty much want me to submit anything from the omnibus and to make sure that we're gonna go to trial.
You don't want to go to trial. You want it dropped.
Yeah,
So I mean, I don't know what they want from you, bro. Like you need to I don't know, bro. I would be getting time. I'd be like, yo, I need more time. Y'all got me in a stressful situation right now. I'm trying to figure out what I need to do. Y'all just are not respecting and honoring anything whatsoever. I'd be hitting that bad boy with a motion to disqualify. And then because right after that disqualify, if he doesn't want to disqualify and he causes problems, what was the next step after that we was going to do anyways?
yeah,
You know what I'm saying? That stay for injunction pending relief was already ready. But I thought you was gonna hit him with the disqualification today. I don't know why you didn't get. I don't know why you didn't get stern and hit him with that.
yeah, yeah. Well, that's the thing that I'm not really used to. Well, this is my first time doing this.
No, but we went
That's
over
why.
that. We went over that, Papa. Uh,
Oh, I know.
and this dude just keep telling you get an attorney. He like, you gotta get an
Yeah,
attorney.
I
You gotta
know.
get an attorney. Man, come on, bro. Why y'all doing that to my boy? We got over 165 people that's on your behalf, signed on your behalf. You in the car. I'm gonna let you scoot and boot, okay, so you can get home. We'll talk later, okay?
Yeah. All right.
All right. All right. Whoa, whoa, whoa. That's too much. Whoa, 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 whoa. That's too much. That's too much. It's too much. Calm down, bro. That's too much, bro. Calm down, bro. Okay. So, yeah, you can see how they playing my boy. They doing my boy dirty. They doing my boy real dirty right now. That's not cool at all. And he ain't stressing on it though, so that's good. And yeah, I don't know why the judge keeps trying to threaten him like that. I don't find that very cool. I find that kind of disrespectful. The judge was supposed to rule in his favor, but they're not doing the right thing here. So he's just gonna bump it up. And what I mean by bump it up is he's probably gonna hit him for a state injunction. He probably gonna hit him with the injunction. So he's gonna hit him probably with the new method, see how that new method worked, and then we just gonna go from there, bro. He wants to go the injunction route, so I guess we're gonna go the injunction route. And yeah, bro, we're just gonna go from here. It's crazy that these judges ain't honoring oaths out here. It's crazy that they're not doing the right thing in relation to no crime. Um, which I don't know why. I would have brought up corpus delicti, verify complainant more. I would have hit very hard on that and relating that aspect. And maybe even next week he could go in with something arguing that if it's within the motion that he put in relation to verify complaint corpus delicti. Just if he's going to argue. But if not, he wants to hit him with the injunction. So I think that's just the route he wants to go. And hey, man, that's what he wants to do. I mean, it's no way that these people going to continue to act crazy on my boy and him not do something. So he's going to have to get drastic with him and step it up to the next level because they not honoring what they supposed to be honoring. And it's a shame. It's really a travesty to see that, you can get, it doesn't matter. Even if it goes to trial, he can make them look really, really bad. And I think what's going to make them look bad, like if he goes to trial, he don't want to. See, I was already prepared to be like, hey, bro, you can hit him hard, bro. You know what I'm saying? Like, trial's going to be really, really cool because he's got how many officers to ask and how many things does he have to put into the record to show the jury how biased they was. And all he has to do is pull into the aspect that the kids are crying, and he just has to pull the certain clips and have in the right things in relation to the transcript to really show that this was an injustice and harm and crime. And the reason being is because they was already ready to let him go until there was another officer that came in and conspired with another department and agency. A whole nother department and agency, y'all. I'm dead ass serious too right now. There was three of them there. One lady was just rude because Luis was standing on his right. She was like, he deserves to go to jail, right? So she's conspiring. Then another one shows up. So now there's 4 cops there. And Luis is at the gas station, y'all. He's at the gas station minding his own business, y'all. And he can literally prove how easy this is to comprehend to a person on the jury in asking the right questions. I mean, trials would be really cool for my boy. I feel like if he, you got the judge over here being like, you should really get an attorney, but I don't know. I feel like we, the people, really have to stand up on all of our rights and help each other out. I don't think he wants an attorney because I know he knows for a fact that these attorneys are only going to try and plea out and not do as he's told, that they're told. He's going to have problems. He's going to have issues. So going into it, I was always thinking trial was, good. We got a whole bunch of stuff developed for that. But when it comes down to it, yeah, judge didn't do right today. And I would have hit right then and there for a disqualification because as much as he laid out for the judge to comprehend and know, and the judge still didn't rule in favor of him, man, that's a baddie right there. That is no way no. Makes you look real bad. And yeah, we just got to really get to that aspect of going to the next level. I mean, you got to start invoking some things here. He brought up constitutional aspects and dudes all like, oh, well, you're pulling into a whole new body. Well, maybe Luis is going to look at the terminology in which was used and get something in there before the meeting next week to speak on that, or just on the spot, which I know they do sometimes, in relation to invoking that. So it's a little bit different than the 8.3 in which was assumed or presumed today. So I think it was a great aspect of showing liberty, truth, honesty. He came through very hard. It's going to be really good for appeal aspects. It's just wild that the state isn't already working in favor of Luis. It's just wild to me. I'm just very flabbergasted by that. So might have to take it up to the highest next court. We're going to have to take it up. Injunctive stay. Move it to the next one. Let's get it up. Because right now there's constitutional violations that y'all are just disregarding as though it's nothing. And you're stating that probable cause is there, but you have to get past a certain element, which is when I say I don't want to talk, I don't have to incriminate myself. And you can't make me talk after that. And they're just disregarding that because there is no crime. So I just want to congratulate and commend Luis for stepping up. He's not letting these people fear him whatsoever. He's standing on all his constitutional rights with his family there, knowing that everything that he's done is in truth. Is in righteousness, is in honor, is in integrity, is in morality. We got 165 people currently on his on his on his campaign. I'm gonna pull it up real quick so I can share it with everybody. I don't know who's on here right now, but if y'all want to go ahead and get we'll move it on up to the higher court, baby. Oh shit, man. Petitions. He's got 156 view petition. And let me share this with y'all real quick. So copy, boom, 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 paste, and then enter. I know it's cold. I haven't had the heater on. All right, y'all. So that's the link right there for the. They didn't dismiss it. The judge railroaded him. You was watching?
Yeah.
This fucker, man. He did him dirty. So we're going to have to take it up to the higher court. You want to say hi?
Hi.
Just come say hi real quick to everybody.
I don't even know any of these people.
There's a bunch of people in here. I don't know how many people, but there's a bunch. Come say hi. Just you got to bend over and see to the camera because the light's not going to shine. They ain't going to see you. There you go. You got to bend. She's like, she don't like it. Okay. All right, well, I'm getting off. I got a lot of work to do. And that's the petition for Luis. Y'all need to sign this real quick. Yeah, we're just going to have to injunct them. We're going to have to hit them with the injunction, bro, straight up. They're playing games with my boy. They're playing games with my boy's family. There's a whole bunch of irreparable harm. That's the way my boy wants to go. That's how we'll go. So, all right, I love y'all. We'll see you on the next one.